Welcome to Chapter 2, Sensitive Data and Special Categories of Data. In this chapter, we will explore the provisions within the DPDP Act concerning sensitive data and special categories and how this data should be handled, the responsibilities of data fiduciaries, and the specific safeguards. In today's digital era, personal data has become one of the most valuable assets individuals possess, making its protection more critical than ever. Among the various types of personal data, sensitive data and special categories of data stand out due to their inherent vulnerability and the higher risks they pose when misused. The Digital Personal Data Protection Act, 2023, DPDP Act, addresses these risks by implementing stringent protections for such data and explores the provisions within the DPDP Act concerning sensitive data and special categories of data, outlining how this data should be handled, the responsibilities of data fiduciaries, and the specific safeguards necessary for processing these categories of data. Definition and categories of sensitive data. Overview of sensitive data. Sensitive data, as defined by the DPDP Act, refers to personal information that, if mishandled, could lead to significant harm or distress for the data principal. The DPDP Act acknowledges that because this data is particularly private and vulnerable, it requires heightened protection and more stringent safeguards than regular personal data. Key provisions under the DPDP Act. Sensitive Personal Data, Section 2 of U. The Act categorizes certain types of personal data as sensitive and provides them with enhanced protection. These include health data. This includes medical records, treatment history, and health services provided to an individual. Biometric data. Fingerprints, retina scans, facial recognition, and other biometric identifiers. Financial information, bank account details, credit card information, financial records, and transaction histories. Sexual orientation, data related to an individual's sexual preferences or identity. Religious or political beliefs, data about an individual's religion, political affiliation, or opinions. Genetic data, information related to an individual's genetic makeup, which could reveal health conditions or predispositions. Caste or tribe data, information about an individual's caste or tribe, which is considered sensitive, especially in the context of India. Special categories of data, Section 8. In addition to sensitive personal data, the DPDP Act includes provisions for special categories of data. This category requires additional protection and restrictions due to its potential misuse. Special categories include sensitive data related to children, vulnerable individuals, or any other data that can severely affect individuals if misused. Example: health-related data, such as medical treatment history, could severely affect an individual's dignity, financial standing, or well-being if mishandled or exposed. Processing of sensitive personal data. The DPDP Act lays down specific guidelines for how sensitive personal data should be processed, stressing the need for explicit consent from the data principal before collecting or processing this data. The Act also specifies exceptions for when this data can be processed without explicit consent, such as when it's required for legal obligations or emergencies. Key provisions for processing sensitive data. Explicit consent requirement, Section 6 of 2. Sensitive personal data can only be processed if the data principal has given explicit consent, meaning they must be fully informed about how their data will be used, and they must agree to this processing. Example: a healthcare app collecting health data must obtain clear and explicit consent from users before accessing their medical records. The user should also be able to withdraw consent at any time. Purpose limitation, Section 4. Sensitive data can only be processed for specific, lawful purposes. Data fiduciaries must ensure that the data is not used for any purpose other than what was initially consented to. Example: a fitness app that collects sensitive health data, like weight or fitness levels, should only use this data to track progress and provide fitness-related recommendations, not for unrelated purposes like advertising. Data minimization, Section 4. The principle of data minimization ensures that only the minimum amount of data necessary for the specified purpose is collected. Example: a job application form should only request financial information, like bank account details, if necessary for salary processing. It should not ask for unrelated information, such as political opinions. Data security measures, Section 8 of 5. Data fiduciaries are required to implement stringent security measures to protect sensitive personal data from unauthorized access, alteration, or destruction. This includes encryption, access controls, and regular audits. Example: a financial institution that stores sensitive banking data must ensure that all sensitive data is encrypted both during transmission and at rest, and that regular security checks are performed to safeguard against breaches. Exclusions and special conditions for sensitive data. While the general rule requires explicit consent for processing sensitive data, there are certain exemptions where this data can be processed without explicit consent. Processing for compliance with legal obligations, Section 7. Sensitive personal data can be processed without explicit consent if it is required for compliance with specific legal obligations, such as statutory reporting or compliance with a court order. Example: a bank may process sensitive financial data to comply with regulatory requirements like reporting to the Reserve Bank of India, RBI, even without obtaining explicit consent from the data subject. Vital interests, Section 7. In situations where processing sensitive data is necessary to protect the vital interests of the data principal or another individual, consent is not required. Example: in the case of a medical emergency, a hospital may need to access sensitive health data to provide urgent medical treatment, even without prior consent from the individual. Public interest in research, Section 8 of 2. The DPDP Act allows for the processing of sensitive data for scientific, historical, or statistical purposes in the public interest, as long as adequate safeguards are in place to protect the data. Example: government agencies may use anonymized health data for public health research or epidemiological studies, such as tracking the spread of diseases without the need for explicit consent from individuals. Special protections for children's data, Section 9. As previously mentioned, data related to children must meet stringent processing requirements, including obtaining verifiable parental consent. Sensitive data of children can only be processed for lawful and specified purposes. Cross-border transfers of sensitive data, challenges and provisions for cross-border data transfers. One of the significant concerns in data protection is the transfer of sensitive personal data across borders. As organizations operate globally, the DPDP Act establishes specific guidelines for transferring sensitive data to other jurisdictions. Adequacy decision, Section 16. The central government can issue an adequacy decision for countries or regions that have strong data protection laws, allowing the free flow of sensitive personal data between India and these countries without additional safeguards. Example: if the European Union, EU, has been deemed to have adequate data protection laws under the GDPR, then personal data can flow from India to the EU without further regulatory restrictions. Standard contractual clauses, SCCs. In cases where an adequacy decision is not in place, businesses can use standard contractual clauses, SCCs, to ensure that the data is processed in compliance with Indian data protection standards. Example: an Indian company transferring customer data to a US-based vendor must ensure that the vendor complies with the same data protection standards as those outlined in the DPDP Act through SCCs. Key takeaways. Let's recap the key takeaways from this chapter on sensitive data. Sensitive personal data includes data like health records, financial information, and biometric data, which require enhanced protection under the DPDP Act. Special categories of data, including data related to children and public interest research, have additional protections. Cross-border data transfers are tightly regulated to ensure that sensitive personal data remains protected, even when transferred abroad. The DPDP Act places stringent requirements on obtaining consent, implementing security measures, and ensuring data minimization when processing sensitive data. Conclusion. The DPDP Act lays out a robust framework for protecting sensitive personal data, ensuring that individuals' most private information is safeguarded against misuse. By adhering to the provisions on explicit consent, security measures, and special conditions for processing sensitive data, businesses can ensure compliance and protect the privacy of their customers. Organizations must be diligent in implementing these safeguards to avoid penalties and ensure that personal data is handled responsibly. Thank you for joining this session. In the next lesson, we will explore the impact of the DPDP Act on business operations, diving deeper into how this vital code operates. See you soon. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed, stay empowered. See you in the next session.